I'm going to the chair of as well, and then dive into quick disclaimer, the standard, and so educational purposes only. We're based in Spokane. For those of us who aren't aware of our firm, an IP our patent attorney goes back to the early 90s with Louis Lee and Dan Hayes to start married to Spokane families here in Spokane, and so that's why we've grown, and Atlanta, Rochester, we have some people who are technically out of some of the other, but we're basically here in Spokane about it. That wasn't the model patent per year, and years ago kind of made an about and decided to say, hey, we moved in general counsel, so we still IP is the single most valuable, but with startups helping establish a corp, do the contractors and giving the IP side, which is trademarks, and then IP commercial. Not a patent attorney. I'll say now I want to. Okay, so we're named. One is to important. Okay, some some basic. Wondering up to this, not enough. You have to have the protection, assets, business assets, the single most valuable asset class. Intellectual property is a economy. So, this goes to the, what do these companies make? Okay, I'm going to hold up my Samsung iPhone. Apple, the company, makes iPhones. iPhones? No. They have someone else make manufacturing facilities. They have another company do that. What do they have? They make only an app. They have the brand itself. In today's world is Apple. The brand. These IP market cap for each one of them. It's just since Google. Okay. Okay, that's one. Well, Google since 269 in the past and so forth. So these people get brands and trades for their company. So Apple's patents on the innovation that they is it the innovation that they see coming up on the app in their app, or if they pay someone to create something for them on a revenue stream for them, for sure. Well, App Store instead of somewhere else. How do you even know where to get to it? They own the URL. They own the software. And itself, for instance, is so there's IP platform, right? And then iPhone sales or computer sales. Cool. Revenue question as they buying, right? And they're buying the asset, right? And the app's revenue generating asset sounds like it's the of any of their assets. Sure. Yeah, it is yes, all of that goes into the valuation of a company. Assets, value of assets, all those things. Trade secrets also, okay? So here's just a few stats. $5 trillion is the estimated value of trade secrets just among U.S. public companies, okay? And there's an estimated $300 billion lost to trade secret theft. Okay. So really what we're talking about is two macro events that have made forced IP into the forefront of today's economy. Number one is we're in a global innovation economy, and then number two is the markets have woken up to the fact that innovation plus protection equals value and prosperity. And it's now become the single most valuable asset class of today's economy. July 29, 2016, a very significant date for everyone, I'm sure, right? Okay, well, not really. What happened on that date, that was the very first time that the top companies, the top 5 companies, as far as market cap is concerned, were all IP-based, IP-driven companies. It hadn't happened before that. Okay? So we're there. Okay? IP is important. There you go. Emerged as a key IP, or a key asset class. Yeah?
Can you define how a business practice actually falls under the IP umbrella? Definition of intellectual property related to a business process.
Okay, so you're talking about, like, can you protect a business process? So like a business method. Business method. Well, we can talk a little bit about that when we get into patents, okay? Because business methods used to be more easily patentable, okay? These days, it's a lot more difficult to obtain patent protection on business methods. So instead, we approach it from different angles, and this is a perfect segue into what is IP, because IP is not just one of those things, patents or whatever else. IP, when we talk about IP, we talk about really the 4 main buckets, okay? 4 main buckets of IP. Patents, trademarks, copyrights, and trade secrets, okay? So we're going to go through each one of those 4 and talk about them a little bit because they are the keys, okay? If you start a business and you come to me and say, Dan, I think I came up with something that's going to be super valuable. I'm going to make millions. How do I protect it? I say, okay, tell me what you came up with and what the deal is and what your goals are and that kind of thing. And then we try to say, well, this can be protected in this bucket, that can be protected in that bucket, and so on and so forth. But you can't think of IP protection in a vacuum just with one of these types of intellectual property. It should be considered holistically throughout all 4 of them. And so also there's this kind of thing we call know-how. It's kind of the primordial ooze of intellectual property. Okay, before you have something that's identifiable and can be placed into one of those buckets, all you have is know-how. You start a business today, fast forward 1 year, that business is running way more smoothly and you have hopefully more revenue than what you did today. Why? It's because you figured a lot out. You figured out how to run the business. Some of those things, just like who to order certain supplies from, or what lead time is necessary in order for me to make meet my customers' deadlines. Those things are just know-how. You start to build up this intangible thing called know-how, and sometimes we can distill it down into one of those 4 main buckets. The reason why I have another picture of an iPhone up here is that that's a great example of a single device that incorporates all of the buckets of IP, okay? Trademarks, patents, okay? There's patents on all kinds of different things in here, on these things. Do you know why there's certain features on an iPhone and not on a Samsung and vice versa? It's because there's patent protection and they want to have an edge on someone else, and then they cross-license with each other, and now the next version of the Samsung will have that FaceTime Duo thing or whatever, right? And so patents, trademarks, copyright, trade secrets, all embodied in one device that we all have on us probably right now. Okay, any questions before we dive into the 4 buckets? Okay. So we're going to talk about patents first. We talk about patents first because patents are king in the IP world, okay? Patents are king. if you obtain a patent, you can literally have your niche, have your space, and you are the only one able to operate within that protected technology space. Okay, so it's an instant barrier to entry. Okay, and therefore, if it's something that the market wants, it's instant business success potentially. Okay, if you do it right. So that's why we talk about patents. Patents are king. And we always, so if a startup comes to me and wants to talk to me even about, I want to set up a corporation, I want to raise money, Dan, help me do that. I say, wait a second, let's talk about your IP first. Okay, and so we always talk about IP first, and we always talk about patents first, because patents are king, and if you can obtain a patent protection around your technology, then it really does give you that automatic barrier to entry, okay? So patents first. So what does it take to be patentable? And we're talking right now about utility patents, okay? It's the new widget that makes things easier, life easier, the new thing that you came up with, new process for manufacturing something, for instance. The requirements, it must be patentable subject matter, first of all. Okay, not everything under the sun is patentable. For instance, law of nature, abstract ideas, mathematical formulas. Sometimes business methods are abstract ideas and they're not reduced to something that's patentable. So that's that example. But then also they have to be three things. They have to be useful, novel, and non-obvious for utility patent protection. Okay? Useful is the easy one. If you came up with it, it's solving some problem that you are trying to solve, right? It's useful. Novel just means it's brand new. Okay, no one's ever done it before. If someone's already done it, then you can't get patent protection on it, okay? And in number three, the last one is non-obvious. That's the hard one. That's why the patent attorneys make the big bucks. Because obviousness is something like, here's just a basic example. If I say no one's ever done this, applied this process or gone through this process for manufacturing, a chair, and so it's novel because I've confirmed no one's ever made a chair this way. But the question is, has anyone ever manufactured a table that way? And if someone's manufactured a table that way, and someone who makes chairs, someone with ordinary skill in the art of chair making, is aware of this method for making tables, they might say, oh, well, that's obvious. We could just do that with chairs. Okay, that's obviousness. Patent examiners like to reject things based on obviousness all the time. Patent attorneys help fight against that. Okay? Protection afforded, the right to sale or importing the invention or products embodying the invention. Patent protection is a country by country, jurisdiction by jurisdiction property right, okay? And so just because you might get a patent in the United States doesn't mean you have protection anywhere else in the world, okay? If you want protection in Europe, you have to go to each European country and get that protection. Now there's ways to do it that make it easier, and it's not like you have to file today in every single country. If you file in the U.S., you have a certain amount of time to then file, internationally, and hopefully by then you'll have, got some more revenue, raised more money, whatever, so you can actually pay for that foreign filing. The term of protection is 20 years. This is the grand trade-off for the patent system and why it was built into our Constitution. Inventors are provided this exclusive kind of quasi-monopoly on exploiting their invention as an incentive to actually invent something and come up with something new. But in return, you only get that for 20 years, and in return you have to teach everyone else how to practice your invention, okay, so that it benefits society as a whole. Okay, so after that 20 years, it's in the public domain. We see this all the time with drugs, right? Generic drugs coming out. At one point, that little blue pill cost a ton of money, and now it doesn't cost as much because it's generic, and now there's different brands that are doing it, but it's the exact same formulation. Patent protection is limited duration, okay? I think I'll go to the next slide, and then we'll circle back on a few other pieces for utility patents. Okay, so here's an example of a patent. Who here has actually read a patent before? Okay, a few. I encourage everyone to go pull up a patent, just take a look at it. It's kind of interesting, and especially now, that I've convinced everyone that they're so important in today's economy, I encourage you to do it. This is the first page of a patent. This is called the one-click patent, okay, that's owned by Amazon. Jeff Bezos was one of the original inventors, owned by Amazon there in Seattle. This is the front page. People who are IP practitioners, who are patent practitioners, spend a minute on the first page, 30 seconds, okay? All they're looking at is like, okay, patent number, date of the patent, so when it was issued, who the owner is, inventors maybe, and then you read this thing called the abstract that's just like a one paragraph or a couple paragraphs just telling you high level what the invention is. Okay. And then people who are in the IP world turn to the back of the patent, because the very last section of a patent is the claims. Okay, those are the claims. The claims are the metes and bounds of the property right. Okay? So the abstract, if say you came up with something, which I encourage everyone to do on their own, do internet searching, but also go to Google Patents. That's a separate Google search engine just for patents, okay? Google Patents is probably the easiest kind of user interface, and you can just search for keywords and come up with any published applications or issued patents that might meet those keywords, okay? If you come up with, you see a patent, and the abstract talks almost exactly about what you just invented, that's not the end of the road, okay? That doesn't mean, oh, well, someone already did it, it's not novel, I better go use my time on something else. No, turn to the back of the patent first and read the claims, because the claims are, like I said, the metes and bounds of the property right. Okay, so when I say metes and bounds, that's like a surveyor, real estate surveyor term, right? How do I know where my property is, where my house is? A surveyor came out and marked the corners and then gave me a description, a legal description, and that's how I know what I own. This is how we know what patent owners own, okay? And so here's an example of a claim, the first claim of that patent, and patent attorneys joke that they're taught all through their formal education to become good writers, and then once they learn to be a patent attorney, they learn to be bad writers, because all that is one sentence, okay? One run-on sentence. Okay, so again, the front, back, and those are the claims. That's really what you pay attention to. Here's an example of how patents work, okay? So my friend Leslie here is going to be part of my example. So let's just pretend that we've never heard of a chair or a stool or anything that we've sat on before, okay? We just stand, or we sit on the ground, or we squat, or whatever. And so I come up with something, I'm like, I'm sick of standing. I'm going to come up with something I can sit on. And I come up with something that I call a stool, and I bring it to my patent attorney. My patent attorney writes a claim that is a platform, so a device comprising a platform and at least one leg supporting the platform above the ground. That's how my patent attorney describes my stool. And say it was novel and non-obvious, and the USPTO grants me a patent on my stool. I'm the first one to ever do it. Great. I start selling my stools, and I'm the only one that can do it. That's great. I start selling my stools. When people get sleepy, they fall off of them. So my friend Leslie, who is way smarter than me, comes up with something that she calls a chair, okay, something with a back, because she's tired of falling off my stools. So she brings it to her patent attorney, And her patent attorney comes up with a claim language that's a device comprising a platform, at least one leg supporting the platform above the ground. Notice it's exactly identical up to that point. Okay? But then also this other element here, a back support attached to the platform and extending from the platform in a direction opposite at least one leg. Leslie can get a patent on her chair because that's new. This claim taken as a whole is novel and not obvious because my stool patent doesn't talk anything about a back support, and so hers is what she obtains is an improvement patent. Okay, my patent is a foundational patent and it's broader. Okay, her
Improvement patent or design patent?
design patents will come next, not a design. Improvement patent, all it is just that it improves upon something else that's been out there. Okay, basic. So you can imagine today the patents that are issued, the vast majority of them that are issued are improvement patents. Someone first comes up with one of these things, a mobile device that can do certain things and has processing and connected wirelessly and that type of thing. And then all of a sudden it unlocks a whole industry, right, of things that can be done with these devices. And so someone, Leslie, who's smarter than the phone maker too, can come up with a new functionality for this, and she can get a patent on that, but it relies on the base technology. She wouldn't be able to do her unique improvement if it wasn't for this base technology, okay? So I have, in this case, I have the base technology of the stool. She has the chair. The USPTO both grants us patents. Can Leslie go out and start making and selling her chairs? She has a patent, right? So she has a patent. She can go make them, right? Okay? That's actually wrong. Most people, this is the single biggest misconception about patents, okay? Patents do not give you the right to make, use, sell, import your device or your technology that you come up with, your invention. It gives you okay? So she infringes my stool patent. Legs supporting the platform above the ground. It satisfies all of the elements of my claim and therefore infringes my patent claim, and she infringes my patent. She can't sell her chairs. Can I sell her chairs? Me from, and anyone else from making chairs, anything with a back support. So we're stuck, right? No, we're not. Yes, that's exactly right. That's exactly right. So what do? This is a prime example of a cross-license opportunity. The market wants chairs. Some of them want my stools still, but they want chairs. So I say, okay, Leslie, I'll give you a stool. Okay? One of the main points to all of this is it is never too late to get into the game. And you don't have to be, the patent system levels the playing field for people. Yes, the big, huge companies with all the money, okay, file way more patent applications than you could ever file with your startup company, and they can afford to enforce them, which is another layer to all of this. But you can get in the game. If you innovate something and obtain a patent for something that the market wants, then you're in. You can sell it and you can exclude others. And someone might say, well, if you made something that Apple wants to make, they'll just steamroll you, right? And just call your bluff. You're never going to sue us. It's PR suicide, right? You don't want, no company wants to intentionally infringe someone else's intellectual property. So they might not know about your patent initially, but you bring that to their attention, then you work out terms and hopefully you can get them to license it or stop so that you can have, or stop infringing so that you can have your exclusive rights. It's never too late. Oh, I think I have the good news. It's never too late. Jump the gun on that one. Yeah, so the patent application, in order to be a proper patent application, has to describe the best mode of making and using your invention. Okay, so that's what a patent application is. That's why it's so robust and costs a lot of money, okay, which we'll talk about as well. Is because the patent application has to describe the current state of the art, how your thing is different, and then give all these pictures of what your invention is, and then tell people what the claims are. So your patent application is what teaches people how to use your invention. Okay. No. Nope. That's correct. Yep. Okay, so a couple of other things about patents. For startups especially, okay? It costs a decent amount of money to get a patent, okay? We quote people off the street $8,000 to $12,000 for a patent application just to draft it and get it into the hands of the USPTO, okay? Then the USPTO doesn't look at it for about 1 to 3 years. When they pick it up, what do? They usually reject it, okay? We affectionately refer to the USPTO as the rejection office some days. Okay, they issue in those rejections, they issue what's called an office action, okay? And the office action has a deadline for responding to it, or else your application goes away. Your patent attorney then has to argue against them. What they do is they say, well, they do a prior art search and figure out, if there's anything that any prior patent application or issued patent or even a white paper published on the internet that teaches about your technology. And they assemble all this prior art and learn about it, and they say, well, given the state of the prior art, your claim right here are rejected because it's either not novel or it is obvious, okay? And they'll reject claims, and then you have to argue and say, no, that's different than what we're doing because of X, Y, Z. And they say, okay, well then if you put in these qualifiers in your claims, I'll accept it. So there's kind of a back and forth that goes on there, and that's the prosecution process. So it takes a lot of time and costs a lot of money to get a patent. The application alone, $8,000 to $12,000 initially. Then a couple years later, they're going to reject it, and you have to pay a patent attorney to argue against the patent examiner to eventually get the patent examiner to agree on something that's allowable. Okay? So patent pending, as soon as you file that application, you can say patent pending.
And then you can use that as an asset.
It's
licensing, like for me, I would be licensing
you can't technically you technically don't have anything to license until the patent's issued. Okay, so most patent licenses, the royalties don't kick in until the application issues into a full patent. Okay. So provisional, all a provisional is, and that's perfect. I was going to go there next. A provisional application is, all it is a placeholder, okay? A provisional application is just, I don't have the time or money or whatever to file a full utility application, and instead I'm just going to do a placeholder that describes what my invention is, and it sets your stake in the ground as far as I'm staking a claim in that invention before anyone else, because the first inventor, if you invent the exact same, if I was inventing a chair at the same time that Leslie was, but she got to the USPTO first, nowadays that means she has the rights to get a patent on it and I don't. So it's the first inventor to get to the patent office gets the rights. Okay, so sometimes if you know someone else is innovating in the same area, or if you don't have the money for a full utility, or if you don't have the time to develop a full utility application, you just get something filed, stakes your claim, and then within 1 year you have to file a full utility application, or else that provisional goes away, it's abandoned. Okay, so a couple of things about that. We almost always encourage our clients to avoid provisional applications. Okay, only in certain circumstances do we encourage people to consider a provisional. It's usually when someone comes and says, hey, Dan, I'm going to go to a trade show next week and display my new thing that I came up with. Oh, no. We need to get something filed first, right? Before it's disclosed. And I'll talk about that in just a second, too. Or I don't have 10 grand to spend on a full utility application, but I can scrape together 2 or 3 grand and pay a patent attorney to help me with a provisional. Heck, even a provisional can be just, your white paper that you draft, and it's the shoebox approach. Scrape everything that you've developed, relating to this technology into a shoebox and just deliver it to the USPTO. Yeah. The problem is it has limited value. It just doesn't have, the amount of time you put into a patent dictates the amount of value it has to. If you rush and file a provisional right now, and then you start to go to market and develop your technology a little bit more, maybe a month or 2 from now you develop new things because you didn't take the time to really flesh everything out. And all of those new things, they can't claim priority back to that provisional because they weren't in the provisional. Okay? And when you go to file the full utility, it might still cost 10 grand. It's not a dollar for dollar deduction in the price of the full utility necessarily. If you do the provisional right with a patent attorney, then it will be a jump start for the full utility and save you money. But it's not necessarily dollar for dollar, okay? So most startups, I encourage them, if you're serious about this and you have something that's patentable, then let's go for a full utility and let's do it right. Yeah. Yeah, so the provisional application does not start the examination timeline. Only when you have the full utility utility application does it start that examination timeline. So that's when the 1 to 2 year clock before it starts is the full utility. But you get any utility first, or that becomes your priority date. Okay, for purposes of you having the priority to that invention versus someone else, okay? In the United States, we have a 1-year safe harbor from either the date of first sale or the date of first public disclosure to file patent applications. 1 year. If today you got up in front of the room and totally told us everything about how you made your new widget, okay, that becomes your disclosure date. And if you don't get a patent filed within 1 year of today's date, then it's in the public domain. You don't get the rights. Okay, yeah.
So from initial raw bootstrap startup, here's our concept, talking about it, to that's your timing. So you have 1 year to raise your seed funds, get your vehicles, get your patent filed.
What we encourage, the way that we encourage, that we counsel our startup clients is, don't disclose it if you don't have to. Okay, and
Trying to raise money.
so here's the key, and I'll tell you how we counsel people on that very thing. How can you not disclose it? You have to, to raise money, you have to disclose what you're coming up with, right? No, you can tell the potential investors the what and not tell them the how. Okay, because the how is what's protected by the patent. Okay, the what just here's the problem that we look to solve, and here's our solution. Okay, that's the what. But we're not telling them anything in the middle. So in your presentations to investors, for instance, anyone trying to do mind to market? Yeah? Okay. So in your presentations, if you're getting ready to present to investors, you present the what and get their mouth watering a little bit, right? And then when they're like, how did you do that? Like, what's your angle and how'd you solve that problem? Then you say, I'd love to talk to you about it and share more info. I need you to sign this non-disclosure agreement first. Okay? No investor will sign an NDA before they're actually interested, right? If you say, well, I'll pitch in front of you guys, but you have to sign an NDA first, they're like, no, bye-bye. In fact, I've heard some investors say that if you cannot pitch me your business concept, your business, without me signing an NDA, then I'm not interested. I already know I'm not interested. Okay? So, do your own searching first when you think you have something. And then, so really the first step is try to define what it is you think you have. What are the novel and non-obvious aspects to what it is you invented? Then do your own keyword searching on Google Patents, that type of thing. And then you can figure out if you want to go down that path. But you need to be able to draw that line and say, here's the what and here's the secret until we have a patent application filed. Okay? Couple of other things. When you're searching for patents, similar patents, you're actually searching into the past, unfortunately. Because if I file a patent application today, it will not be made public. It will not publish for 18 months. Okay, so if I search for, I came up with a new widget, and I search for widget technology and other patents issued on widgets, I'm unfortunately searching into the past. I can't tell what Leslie just filed yesterday. And that's just one of the many risks associated with starting a company. It's the best you can do, is searching into the past. You still should do it. Okay? Questions on utility patents? Okay, usually when we're talking about patents, we are talking about utility patents, but there is also design patents. This is really kind of the fifth bucket of IP, but it's under the patent umbrella because only patent attorneys can still do this, even though it protects something very different. So it's the look of the phone, or the look of the hood, the contours of a hood of a car. Okay. So examples, devices and products, but also graphical user interfaces, GUIs, okay, can be protected by design patents. I have one client down in Austin that's launching next week. They're launching in coordination with that next week. What are they doing this week? They're working with one of our patent attorneys and filing a bunch of design patents, patent applications. Okay. So it's the right to exclude others from making, using, selling, offering for sale, or importing, so the same as utility rights, but the infringing goods. And instead of it being 20 years from the earliest filing date, it's 15 years from the date of issuance for design patents. So here's a little example of how design patents work. So this is a design patent on an iPhone again, and the bezeled edge is claimed as a component, but the back is not. That's the dotted lines. Anything in dotted lines is not claimed component of the invention, okay? So then we have a Samsung over here that has the beveled edge in the same kind of general look, and the back is different. That's not claimed in the design patent. It's infringing, okay? Design patents, you shouldn't fall asleep on design patents. I have a lot of companies that design patents aren't really that relevant, but if they are relevant, they're easier and cheaper to get than utility patents, and they have really, really good teeth to them. They're easier to enforce. They have really easier to get damages, okay? Design patents are a very, very valuable piece of the overall IP portfolio for companies, okay? Again, so I said like $8,000 to $12,000 for a utility application. For a design application, it might be 3 to 5, okay? And the examination process is a heck of a lot faster. They'll pick it up within the year. And actually, you can get a design patent issued a lot of times within 6 months to a year, okay? Yeah, so each individual design of your graphical user interface would be a separate invention for a design patent. Would be treated separately. So you want to get kind of the general thing, and I'm not an expert when it comes to GUIs, but I happen to have one of the best experts in the United States on design patents here in our Spokane office, but yeah, to answer your question, it's each individual kind of graphical user interface. So for one software platform, you might have a whole handful of design patents on each. Looks like, okay. And so kind of when to use an attorney on patents, go first thing. This is the very first thing you should talk to an attorney about for startups, even before you talk about starting your, forming an entity or raising money, okay? All of that should flow from this conversation. You say, I need to protect this in order to be successful, to put up barriers to entry, and have some sustained business model here. In order for me to do that, I need to raise this much money. Well, now you know how much you need to raise to pay that patent attorney to do that. Okay? Then we can form a corporation. Then we can start helping you raise money the right way without violating securities laws, that type of thing. Okay? Questions about patents? I got to move forward so that we're not here all afternoon. I think it's already 12:50. So we're going to kind of go a little bit faster on these other things. There's a reason why we start with patents and that we take the most time on patents. Okay? We need to be able to cross that box off the list. If it's not applicable to you, you can move forward. But you need to at least think about that first before you move on with other things. Trademarks. Patents are king, but trademarks are awesome. We kind of all understand them, right? We get what trademarks are. We're inundated by them everywhere. Epson, Dell. We have a bunch of company logos around here. Each one of those are trademarks. Okay, we know what trademarks are. Not only that, we're inundated by trademarks at a very, very young age, very early, right? Those golden arches meant something to me when I was a little kid. My second oldest child, when he was about 18 months old, driving down the road, he sees a sign and he says, Jimmy John's! Jimmy John's! What? That kid can't read? How does he know that it's Jimmy John's? Because he can recognize the sign. The logo means something, and it means that yummy, scrumptious sandwich that he likes to eat every once in a while. Right? So we get trademarks. Trademarks are awesome. So what are trademarks? Trademarks are source identifiers. They're anything that is a source identifier. Okay, so not just the word Dell, not just the word Apple, but also the logo, right? The slogan, Nike, just do it. Package design, or the design of a product itself. You can have trade dress protection, a registration on trade dress, on the exact same thing that you have a design patent on. Good strategy. A lot of people do it. Look at Apple, that's what they do. What about colors? Colors can be trademarks? What? Alone? Well, let's think about, again, cell phone carriers, right? So mobile service carriers. Who do you think of when I say pink? T-Mobile. Who do you think of when I say blue? AT&T. Verizon, what are they? Who do you think of when I say red? Red. Verizon. What about yellow? Holy cow, you just proved that colors alone can be trademarks. They are in your mind, we're all consumers of those services, okay? And in our minds, that color, if I walk into a cell phone store and it's yellow, I know I'm in the right place for Sprint. It's a source identifier and it's protectable, and they can sue each other if they use each other's colors, okay? They have to be used in commerce in association with the sale of goods or services. So as soon as you start using a mark in connection with the sale of your goods or services, there are some trademark rights. It's not like patents. Patents, you don't have the rights until the government says you have the rights. But trademarks, as soon as you start using them, we're in a common law country. As soon as you start using them, you have some rights. Okay? Yeah. The sale. First sale of your goods or services. Under the mark. There are some certain circumstances where pre-sales and pre-sale activities could count as most circumstances, it's the date of that first sale. Okay? So everyone should know when they made their first sale of their goods or service. Okay, that's your date of first use for your trademark. Distinctive has to be distinctive either inherently, like I came up with a word like Exxon, and that's distinctive. No one else is using Exxon. It's a made-up word. Or it's acquired. You have some acquired distinctiveness. We have what's called the spectrum of distinctiveness in the trademark world. On the one end are very highly protectable marks. Those are arbitrary and fanciful marks. Exxon, or Apple for computers. Everyone knew what an Apple was. We eat them, but never associated Apple with a computer or phone before this company. That's a highly protectable, highly distinctive mark. On the far other side are the marks that are not protectable ever. They're generic marks. If I started a brewery and named it beer, that would not be protectable because I can't keep other people in the brewery space from using the word beer, right? Generic marks are never protectable. Descriptive marks are sometimes protectable if they can be, if they acquire secondary meaning. So at one point, Fat Burger might have just been, the name of any old burger joint that made really big, fat, juicy burgers. But at a certain point, in the minds of consumers, we hear the word, that mark, that word Fat Burger, and know that it's that place and not that place. Okay, that's acquired distinctiveness. Suggestive marks and descriptive marks are suggestive marks are really the sweet spot for startups and smaller companies because it tells people, consumers a little bit something about what it is you do. Okay, so you don't have to name your company Exxon and then spend all this marketing money teaching them what that means and how they should associate that with your goods or services. A suggestive mark is like Microsoft, software for microcomputers. Oh, I get it. If you have that aha moment, oh, I get it, that's when it's a suggestive mark instead of a descriptive mark. Okay? So a lot of times, so if I was starting a software company, I might actually do something like, Zebra, something arbitrary, but say it's Zebra software. So people know what I'm doing, but Zebra is highly distinctive and protectable. May not be the same. Okay, so when you are choosing a mark, I tell everyone before you even come talk to me, go do your own searching, internet searching, and uspto.gov. You can search their trademark database. Okay, and you look for the exact same marks, but also similar marks. Okay, and what if I found? So what if I was a brewery, or we'll just use Zebra software. And so I was starting Zebra software. I was doing some searching, and I found a Zebra in Spokane, local and everything, but it's a landscaping business. Do I care? No. Because it's not, consumers aren't likely to be confused. It's the Delta example. Delta Tools, Delta Airlines, Delta Faucets can all coexist harmoniously using the exact same word as their main brand because consumers would never believe that the airline was making your faucets or the tool company was flying your planes. Likelihood of confusion. Okay, so it's not just the mark in a vacuum. Okay. If you spell a word different in a different language, or it's one letter off, it's like zebra but with a C instead of a Z. If it still sounds the same, I might be too close to the other Zebra software, for instance. Okay, so those are things to think about. Have to be non-functional. So if you have, especially like packaging design, it can't be functional. Or like a color, if you make something so that it's easy to see and reduces the risk of hazards, and that's why it's bright yellow. That can't be a trademark because it's functional. Okay. Protection afforded protects against consumer confusion and/or dilution of the trademark. Famous marks can sue for dilution. So where I said, Delta, there's all these Deltas out there and they can coexist harmoniously. If I started a landscaping service called Google, they could still come after me for dilution, even though there's not a likelihood of confusion because Google's a household name, household brand. Okay. The term for trademarks, this is huge. Unlike patents, They're potentially perpetual in duration. Think about Coca-Cola. Think about McDonald's. How long has Coca-Cola been around? A heck of a long time. Okay, and they're going to continue to be around for several generations at least. Probably until people stop drinking soda. I don't know. Okay, so example. What's the difference between these two pictures up here? Gonzaga sweatshirt, Washington State sweatshirt. Not going to make any jokes about the basketball team. I'm a Zag. I'm a double Zag. I love the Cougs. I've always been a Coug football fan, growing up on this side of the mountains. But really, the difference up here, you can see right here next to the Coug logo, there is an encircled R. Okay? Over here is just a TM. TM over by the Gonzaga. What does that mean? You cannot use the encircled R until you have a federal trademark registration. Okay? But, like I said, you have some trademark rights as soon as you start using your mark in connection with the sale of your goods or services. Those are common law trademark rights. The TM just tells people I'm claiming common law rights in that mark. Okay? Whoa. Gonzaga doesn't have a registration? No, they do. They have trademark registrations, but for I haven't looked in a while, but academic services and promotion of sporting events, not necessarily for sweatshirts. Well, guess what? Gonzaga is the name of a saint. The Bulldog. There's a ton of Bulldog logos out there. It's kind of a sticky thing. There's a reason why it's different. This is very distinct. The WSU thing. They need to get that registered. Okay, but you better believe that Gonzaga can still enforce their common law trademark rights. They're very enforceable. But go back 30 years. Okay, go back 30 years. Common law trademark rights are geographically specific to the extent of your notoriety. Okay? So go back 30 years. Who knew about Gonzaga University? Maybe just in the Northwest, maybe a little on the West Coast because we played some California schools. But if someone wanted to make a Gonzaga University sweatshirt or just a Gonzaga sweatshirt in Maine or in Florida, they probably could do that, and Gonzaga probably couldn't have stopped them 30 years ago. Now, we are the #1 team in the country for basketball. Basketball has propelled Gonzaga into the nationwide consciousness, and you better believe that they can sue someone in federal court in Maine or in Florida or anywhere else in the country because the geographic reach of their brand is now much broader. Okay? So a little example. Mattoon, Illinois. Okay? Small town in Illinois, central Illinois. Mom and pop Burger King. The big Burger King comes and says, hey, we're expanding into this area. You need to change your name. The mom and pop fights them and wins and says, actually, we had our common law rights before you had your federal registration. And we can carve out our tri-county area. And within that tri-county area, if we proved to the judge that in the minds of consumers in that area, when they hear Burger King, they think of us and not you, then we own Burger King in that area. Now, we can't expand because once you got that federal registration, you locked me in place of my geographic notoriety, but you can't come in here. Okay? What about Sonic Burrito here in town? When I was an undergrad, when I heard Sonic, I thought of the burrito place. So it's the same thing as Burger King, right? Except for the fact that the Sonic Drive-In had their federal registration back in the 1950s. And so when they decided they wanted to come into Spokane, all they had to say was, hey, we have the rights. Sorry, you need to change your name. I was very upset about that at one point, I like that burrito place. Come to find out, my colleague, who's now in the office next to me, represented the big guy at his prior firm. I don't think I'll ever forgive him for that. Okay, likelihood of confusion. I have a lot of alcohol examples. I head up our wine, beer, and spirits group, so I like to work with wineries and breweries and those type of companies, but especially because trademarks are just a total mess in that industry. But this is just an example. Maker's Mark has a trade dress registration for the design of the red dripping wax. They successfully sued a Jose Cuervo distributor when they started and got a judge to stop them from distributing this bottle on the right with the red dripping wax. Because they proved that there's a likelihood of confusion. Would you guys be confused? I gave the presentation at Gonzaga a couple years back, and I said, what if it was a green dripping wax instead of red? Would you be confused? They said, no, we just assumed that the liquor was a different flavor. So, well, that's a very college view of buying liquor, flavored liquor. Yuck. Okay, holistic brand. So for trademarks, we also want to look at things from a holistic approach. So Apple has trademark registrations on each one of these things. The word Apple, the Apple logo that we're all so familiar with. They also have a trade dress registration for the shape of their icon. No one else can use that exact icon, okay? They even have, so they have design patent protection on the shape and look of their iPhone, but they also have trade dress registration for that as well. If it goes away, guess what's still around? Their trade dress, trademark, okay? They even have a trade dress registration for the look of the Apple Store, okay? They don't have a registration for that. What I mean by the clip art I had for the police officer here is it's all of these things plus policing their marks and enforcing their trademark rights means that brings them to the single most valuable brand in today's world, business world, okay? That's Forbes does an annual list of most valuable brands, and I think the most recent was $182 billion just for the brand, okay? Trademarks are a different type of intellectual property. If you do not enforce your rights against a known infringer, then you might actually lose your rights. You might be deemed to have abandoned those rights. So there are a ton of trademark cease and desist letters floating all over the place. Okay, I tell people, don't take it personally. It's just a guy like me on the other end telling them that they have to send you a letter. Their hands are tied. If they want to maintain their rights, they need to send a letter. Excuse me. Every single business has IP. Doesn't matter what you are. The mom and pop grocery store up the street has IP because every single company, every single business has a brand. Has a trademark, whether it's registered or not. There are some rights there. Okay, questions about trademarks? Oh, okay, well, I'll give you the rundown. When to use an attorney. First consultation is usually free for most attorneys. Do your own searching. As soon as you decide and you say, I'm sold, I'm going to use that mark, go buy a domain name, go acquire the social media names before you even come talk to me about getting a registration or making a plan of action. Exhaustive searches that we do, we help people do clearance searches. It costs money. Most startups don't need to do that and instead just file the application, see what the examiner says. The registration process is a lot cheaper and a lot shorter than the patent process. We do a $1,000 flat fee, and then the government fees are about $250 per class of goods or services on top of that. So you're $1,200 or $1,300 to get something in the hands of the USPTO. They will look at it and sometimes not reject it, unlike patents. Okay, they look at it within 3 to 4 months. Okay, you can get a trademark registration in about 9 months to a year if everything goes smoothly. Okay, there is a way there's a publication period for 30 days when anyone can come out of the woodwork and oppose your application, and then that's a quasi-litigation situation. But assuming you come away from that unscathed, you can get a registration. You have presumptions, automatic nationwide presumptions of exclusive ownership with a trademark registration. We tell people that a trademark registration is really a no-brainer if you're going to do business across state lines. You really want to get one, okay? Questions about trademarks? Okay, now we're really going to go fast about here. But copyrights, if patents are king, copyrights are kind of the queen of the IP world. Copyrights derive from the Constitution as well. And we all kind of understand copyrights, right? I mean, I write a book. I own the copyright for that book. I take a picture or I In fact, you own it right away without a registration or without by copyright. You own that. Those notes. These slides are protected by copyright because they're in a fixed medium, okay? So it's a tangible form of original expression. The tangible really means a fixed form. Tangible doesn't mean it has to be printed. It can be, electronically stored. Has to be fixed. And then the minimal creativity, it's anything, even a phone book can be protected by copyright. Okay, the layout of a phone book. Yeah.
So there's someone Todd's business model needs to be copyrighted instead of patent.
If he puts it on paper, the flow chart of it that's protected by copyright, but it doesn't mean that someone can't go. All that means is that they can't go publish the same thing, like in their own book or whatever. But they can learn from it and use it because it's not protected by patent. Okay, it protects a different element of potentially the same thing. Software code. Okay, the functionality of software can be protected by copyright, can be protected by utility patents, and the graphical user interface can be protected by design patents. But code itself and the overall look and feel of your user interface is also automatically protected by copyright. You don't have to do anything. It's automatically protected. You can automatically start using the encircled C. At the bottom of all of your websites, it should be the year of last update. Okay? So encircled C, the year of last update, and then the name of the owner. Okay? Registration is not required, but it is a good idea if you're building your business on something that's protected by copyright, like you're a musician or an artist, or you are building a business based on your software. Software should be registered. It's pretty easy. In fact, that's the one type of IP registration that we tell our clients that a lot of times you can do it yourself. Now, we do it for clients, especially with software. It's a little tricky, but the Copyright Office is way more user-friendly, I believe. Okay? A copyright owner has the exclusive rights to reproduce, prepare derivative works, distribute copies, perform, display, transmit, etc. Okay? And copyrights, unlike trademarks and patents, which are jurisdiction-specific, okay? Just because I have a trademark in the U.S. doesn't mean I have a trademark in Canada. Okay? Copyrights, there's an international treaty that will provide for protection in different countries if you have the registration.
Again, I'm in development stage, right? So
Put the encircled C. It's there.
it's there.
As soon as, so do you have are you software based?
Yeah, so we do have that.
So
That's really
as soon as you release your first version, you want to registration. So version 1, published this date, and there's I don't have the dates up here, but you want to register it within a certain amount of time from publication. Okay, so it's something you want to do in order to if you do it within the certain amount of time, you get that registration. Then if you do ever enforce it against someone, you can get triple damages and attorney's fees. Well, I mean, usually, so sometimes people will register a beta version, but usually people wait until their final version. Betas are usually not distributed widely, right? So the chance of someone, unpacking your code and stealing it or doing something else is pretty low. The most common copyright infringement story or fact pattern for in software world is a disgruntled employee or someone who takes this code or knows what you did to create that code and then goes to a competitor and creates a competing software product. Again, it's a limited duration of protection. This is a trade-off type of a thing like patents, but it's a lot longer. Life of the author plus 70 years, or if it's a work made for hire, it's 95 years from first publication date or 120 years from creation. What is a work made for hire? A work made for hire is something that an employee creates within the scope of their employment, then not only does the employer own it, the employer is the author for purposes of copyright law, okay? There's other specifically enumerated things that can be work made for hire if you hire a contractor to do it. For instance, a translation or a map. If I said, hey, I have this, go make a translation for me and I'll pay you, that's automatically a work made for hire. But not everything that a contractor does is work made for hire. This is the single biggest takeaway that I'm about to tell you for copyright law, okay? If you pay someone to create software for you or something else, even a logo for you, and you don't have a written agreement that says that they hereby assign those rights to in what they created in the IP rights, associated copyright, and other IP rights related thereto to you, then you probably don't own it, even though you paid for it. What does that mean? Okay, Leslie is a brilliant software developer. I come up with a startup, I start my startup company, I hire her to create my MVP. It's awesome. I start to make some money. We had a written agreement, but it doesn't have an active assignment language. She gets paid, she's happy. I get my software, I'm happy. Next year, I want to do version 2, and I want someone who has skill in coding this other way. I say, okay, great, we'll take all this code and use that for version 2. And Leslie says, whoa, whoa, whoa. I didn't give you the right to do that. And I say, what do you mean? I own it. I paid you. And Leslie's smarter than me again. So she points at the contract and says, I never assigned it to you. All I'm doing, even if it says that we both agree that you own it, that's not an active assignment. Okay, so ownership is the single most prevalent issue in the IP world. We deal with ownership issues every week. Every week we deal with IP ownership stuff. Okay? And this is one of the most common ones. Just even a logo. They'll come to me and say, I want to register my logo and my word mark for a trademark. And I say, great, who created your logo? And I said, well, Leslie did. She's also a logo creator. And I say, well, do you have a written agreement with Leslie? Well, yeah. Okay, great, let me see it. No, this isn't good enough. You need to have Leslie go sign it. Guess what? Leslie might want to get paid more. She might want a second bite of the apple. That's a problem, right? You got to do it right the first time. This is one of the biggest takeaways for startups is this piece of advice right here, okay? It's not advice, it's information. Okay, so how copyrights work. Ideas in and of themselves, okay, are not protectable under any bucket of IP. Just ideas alone are not protectable. The expression is what's protectable under copyright law, okay? For instance, code, okay? So if I go to Leslie, my coder, and I say, Leslie, I want a software product that does this, this, and this, and has all this functionality, and takes these inputs and has these outputs, and you go make it. Even though I told her everything about, I gave her my wish list of, that's just the concept. I don't own anything about that. She's the one that actually writes down something that's tangible. She owns the copyright. What about, I'll take my phone, for example. My phone's cool because it has a camera on it. Okay, most people have cameras. I give my phone to Leslie and I say, hey, Leslie, I'm giving a presentation. Take a picture of me. But I don't want you to just take a picture from your chair. Stand up on the table and take a picture, and don't hold it like this, and maybe at an angle. And so I take all of the creative aspects out of her hands. I tell her exactly how to do it. It's my phone, and it's a picture of me. Who owns the copyright? She owns the copyright simply because she pushed the button. She's the one that fixed it, that snapped the image, and so that it's now fixed into a tangible, form. Okay? Should have brought my selfie stick, exactly. Yeah, that's right. That's one of the biggest misconceptions for copyright stuff, okay, is ownership. Okay, real quick, questions about copyrights. You want to talk to an attorney also about copyrights if you think you have something protectable. Questions? Copyrights? Okay, real quick, trade secrets. Trade secrets, I feel bad going quickly because they're always treated as the stepchild of the IP world. They're always kind of forgotten. Trade secrets are hard because it's hard to they are an asset. Sometimes they're a very valuable asset. Especially, for instance, I came up with the next thing since sliced bread. It's patentable, but I haven't submitted the application yet. That should be treated as a trade secret. Okay? And so it could be the most valuable asset of my company. But it's hard to even talk about it because the point of trade secrets is you're not supposed to share it. It's supposed to maintain as a secret. In order to be a trade secret, it has to be, one of these things that derives independent economic value and is subject to reasonable means of secrecy, of maintaining secrecy. Okay, so what that normally means is you don't go sharing it around, you don't go unless you have a non-disclosure agreement with someone or non-use agreement. You don't publish it. You maintain password protection on your computer if it's stored in your computer. Only a few people in the world know about it even or know the full thing. Those are reasonable means of secrecy. Okay? Otherwise, the protection's not there. And the protection for trade secrets is pretty robust. We have federal level protection. You can sue in federal court now. That's pretty new. But you have state law, good state law protection as well. And in fact, there's criminal statutes prohibiting misappropriation of trade secrets. People can go to jail for economic espionage. Okay? Trade secrets are potentially perpetual in duration as well, just like trademarks. But that's not really likely these days because it's so hard to keep them secret. If I'm a disgruntled employee, I have, again, this cool thing. It's called a phone. It has a camera on it. And I take a picture of whatever is on my screen, and in 1 or 2 clicks, I can publish it to Instagram or Facebook or you name it. Okay? It's all of a sudden not a secret. Okay? This is why, it's really important to have employees sign things up front. Confidentiality, invention assignment, and sometimes non-compete obligations for employees. Because not only am I saying you can't disclose the secret stuff that you're exposed to while you're here, but if you went to a competitor, there's no way that you can keep from sharing some of my valuable stuff, so you can't even go to a competitor for a couple of years. That's non-compete. Here's an example, trade secrets in practice. We know the KFC secret herbs and spices, right? Those are trade secret. The Coca-Cola recipe, they have tried to imitate Coca-Cola and can't just do it right. They can't do it right. They know what the elements of that formula is, but they just can't make it taste the same. There's something secret about it. Maintain it secret, and that's a trade secret. Okay, and of course, anything that's patentable before you've published or file a patent application. So here's just some thoughts about trade secrets. Talk to an attorney if you are building your company on something that you think is a trade secret or you've identified as a potential trade secret. You should talk with an attorney who has experience with trade secrets to help you establish kind of your policy for trade secrets. How are you going to maintain the secrecy and maintain it as a trade secret? Okay, and sue that disgruntled employee or their competitor, or excuse me, your competitor that they work for, their new employer. You can sue them for misappropriation of trade secret because you poached my key employee and they told you these trade secrets. Okay? So I can sue my employee or threaten to sue them because they're breaching the contract I had with them. So breach of contract for confidentiality, non-compete, whatever it is. But I can also sue their new employer for misappropriation of a trade secret if I maintain it as a true trade secret. Okay? Questions? Okay, so just real quick, I talked a little bit about non-disclosure agreements, non-compete, invention assignment. The other thing about, so going back to patents, we know about copyrights. If they're an employee and create it within the course of their employment, then you own it as the employer. But if they're a contractor, you must have the assignment language. For patents, even if they're an employee and you're paying them for specifically to do R&D and to come up with patentable inventions, You don't own it yet until there's a contract saying they assign it. And in Washington State, there's kind of some magic language that we have to have in those contracts. It's RCW 45 44 140. Hang on. 49 44 140. Sorry, I butchered that. RCW 49 44 140. And that's magic language that you have to have in your invention assignment agreements, or else it's considered void in the state of Washington. Okay? And basically all it is you have to explain to the employee that you don't own any of their own stuff that they create on their own time with their own resources that doesn't relate to your business here. Okay? So that's really what you have to do. The other thing is consideration. You can't have someone start and then a week later have them sign the invention assignment or non-compete or whatever unless you give them new consideration. That means you have to maybe pay them something to sign that in exchange for what they're giving you. Instead, you need to have employees sign before they start. You cannot start until you sign this. Okay? That's all I got.
So what do you do with those NDAs? So what you just said to me, I've done before. When you're going to investors and stuff, generally if you're in a group, they are, they're not going to want to sign.
Hesitant to sign anything, yeah.
Yet you get advice because you're working with somebody who may have left a company or
Yeah.
get it before you talk. Like on that.
It's the same. So the same approach, and this is something that every startup has to go through. You have to determine where the line is. What can you disclose to get their mouth watering, right? Versus what can't you disclose, which is disclosing the secret sauce. And usually that question is answered by separating the what with the how, from the how. Okay? So if you can say, here's the problem, this is what we do, this is why it's a problem, and then we say, and then this is how we've solved, or this is our solution to the problem. We don't say how we created that solution. They say, wow, that's a great idea. And then they say, I want to know how you did that because I don't believe you. Great, I'd be happy to share more info, but you need to sign a non-disclosure agreement. Okay? NDAs, so NDA templates for our clients, our startup clients, if we're doing an incorporation package, which by the way, we're doing kind of what I'm calling a corporation in a box approach. If you are a company, startup that needs to attract and accept outside investment, okay? You're not just a closely held, bootstrap, maybe have rich Uncle Frank giving you some money and call it good. It's an emerging growth type, high growth company that is going to need to attract outside investment. For those type of companies, we recommend a corporation for a lot of different reasons. Usually has to be a C corporation for tax purposes, and we could talk about that at another time. But that whole approach, we've kind of tuned in our startup approach for investment-ready companies to this, what I'm calling a corporation in a box, and we're doing it for right around $3,000. And it'll get a whole host of documents, all of your, invention assignment and stock issuance for founders, employee, non-competition and confidentiality invention assignment agreements. We'll give you an NDA if you don't have one. Articles, bylaws, shareholder agreement, those type of things, board consent. Yeah.
Does ENAs provide any, like Wadkins provides incubation service for certain startups for all their legal needs? Does ENAs provide anything?
So we have, and we've made certain deals with various startups along the way. So we approach it on more of a case-by-case basis. We're an investor in Mind to Market. We also help actually create Mind to Market because we knew it was such a cool tool for the startup community, and will help the startup community in general. So we're big supporters there. Have a bunch of clients that have gone through it, the Mind to Market program, for instance, and depending on the specific scenario, we have various ways to be flexible with startups. So.
I went to Innovate Washington and spoke with John at Wadkins.
Sure, yeah.
And John
which is now Ignite.
Sort of thing,
It's
yeah.
now Ignite.
It used
Yeah.
to be- Is it Ignite?
Ignite Northwest. Yeah.
So it was CERTI, then Innovate,
Yep.
then Ignite.
Yep.
They do that as well, they take companies. And, but you really have to reach them, they're not gonna take anybody. But they also, they recommend you guys, so there's a relationship between Wazoo, seniors doing the work, marketing, that kind of stuff, and then you guys. John over.
Yeah. So the WSU stuff. So the WSU and what they're doing with their business plan competition. I'm actually going down to present there for like the 7th year in a row next week. But Ignite Northwest, we've been involved and have a representative on the board over there, and I've presented there since the beginning as well. So yeah, it's. I mean, this is the place right here. We now, several years ago, didn't have a central hub for figuring out, what resources are available to you, and this is the place now. Okay, so you come here, you get the info, they'll point you in the right direction, and start networking and start figuring out how to make it a reality. So, good luck, everyone. Thank you. I'll be around for a few questions if you're interested. But have a great day. Enjoy the snow. Drive safe.
Thanks for the time.
Yeah, absolutely.
Lots covered.
I just want to make sure this is.